Welcome to the Emerging Litigation Podcast. This is a group project driven by HB Litigation, now part of Critical Legal Content, and VLEX Companies Fast Case and Law Street Media. I'm your host, Tom Hagee, longtime litigation news editor and publisher, and current litigation enthusiast. If you wish to reach me, please check the appropriate links in the show notes. This podcast is also a companion to the Journal of Emerging Issues in Litigation, for which I serve as editor-in-chief, published by Fast Case Full Court Press. And now, here's today's episode. If you like what you hear, please give us a rating. Of all the opportunities legal operations teams might identify to save time, money, and resources, while potentially improving quality, robotic process automation may currently offer the biggest and most immediate opportunities. That's a quote from the forthcoming book, Legal Operations in the Age of AI and Data. Specifically, it's from the Automation in Legal Departments chapter, written by a group of experts, including two of our guests, who I'll introduce shortly. Automating repetitive tasks and workflows required to effectively advance litigation frees litigators and support teams to focus on, quote, strategic, analytical, and high-value work, the authors say. Boosted by AI technology like natural language processing, these tools can conduct data extraction and analysis from volumes of documents, create new documents, summarize documents, or initiate document drafting. And soon they'll write podcast introductions. Who are we kidding? They already do. They ask, how can litigators best leverage these capabilities? Well, let's find out. Let's listen as my first-time guest host, Sara Lord, interviews Tara Emory, who is Senior Vice President of Legal AI Strategy, and Wilzette Louis, who's Director of Client Solutions at Redgrave Data. Tara, not to be confused with Sarah, Tara is an experienced, accomplished, and highly regarded legal industry executive. She's a recognized expert in legal AI, e-discovery, and information governance operations and consulting. Who else do we have on here? Come on, what do you think we're running? She plays a leadership role in the Sedona Conference and served as e-discovery lead on the House of Representatives Select Committee to investigate the January 6th attack on the U.S. Capitol. You've heard of that. Tara holds a JD and an LLM in International and Comparative Law from Duke University School of Law. Wilzette Louis is an e-discovery expert and advisor focused on approaches for using technology and workflows to maximize effectiveness, efficiency, and overall client satisfaction. Wilzette has a BS in computer science from the New York Institute of Technology. This is Wilzette's first time on a podcast, so welcome her to my world. And as I mentioned, my guest host is Sara Lord. This is first time guest hosting for the Emerging Litigation Podcast, and so can you. Sara is a former practicing attorney with a decade of experience in data analytics. Sara applies her experience in large and small firms and businesses to explore and address the cultural and practical barriers to diversity in law. Can you imagine? And client-first, business-oriented practices. As managing director of Legal Metrics, she leads a team of experts focused on providing the tools to support data-driven decision-making in legal operations and closer collaboration between law firms and their clients through using automation and standardization of industry metrics. Sara earned her JD from the New York University School of Law. And may I add, in the time I've known her, I've learned that Sara is whip smart and not without sass. I mean that in a good way. So, listen as Sara Lord interviews Tara Emory and Wilzette Louis from Redgrave Data. I hope you enjoy it.
Wilzette and Tara, thank you both for speaking with me today. And a really big hidey-ho to all the lovely people in podcast land. Welcome to the show. The clock is ticking. So I guess let's just dig in. Wilzette and Tara, you co-authored a chapter on automation technologies in legal for the forthcoming book, Legal Operations in the Age of AI and Data, which is available for pre-order from Globe Law and Business. Can you tell us a little bit about the book?
Yeah, we're really excited about this book. Wilzette and I co-authored this with our colleague, Adam Poppelmeyer, and with Cassie Burns from King & Spalding. And the book is edited also by Olga Mack, Humaira Noristani, and Maymay Onwoodiway.
Wilzette, tell us a little bit about the chapter you co-authored.
Our chapter dives into how automation technology can be leveraged in legal departments to streamline processes and boost efficiency. Technologies that we discuss are robotic process automation, also known as RPA, artificial intelligence, and machine learning. RPA bots can be used to automate repetitive, rule-based workflows. Bots can also be configured to extract data from a website, populate that data into a form, and attach that form into an email. Another example of automation is web scraping. This technique extracts data from websites and stores it in any location that the team wants. Legal teams could utilize web scraping to preserve web pages for their cases or to extract data points that are important to the case. Other forms of automation implements AI and machine learning to handle discrete tasks, requests requiring intelligence, and to analyze data. Some of these solutions are drafting documents, reviewing contracts for risk, creating document summaries, and providing legal research. All of these solutions are designed to free up attorneys and legal teams so they can focus on strategic tasks.
Okay, so that's very exciting. And you've been talking about AI and automation. So let's just deal with the basics first. And when you talk about automation and automated technologies, can you explain what that is for the uninitiated?
So automation technology is taking these repetitive, rule-based tasks that humans perform on their computer, on systems, and having an automated workflow. So you can have robots, which is a terminology that's used for robotic process automation, that can actually mimic a human's processes when it comes to opening up a Word document, extracting data, coded information, creating a report. So automation technology is any rule-based task that we can utilize software to do for us so it would give attorneys more free time to focus on other things, and we'll have more accuracy on the results of the end product.
How is that different than the AI automation that's built into Google, Apple, Microsoft, or in law, e-discovery, document management, legal research tools? Or is it not any different?
Well, it is different, and that's because these companies, these technical companies and these vendors, when they create a product, it's solo. It's based on their particular task, the particular workflow, the particular service they're trying to provide. Automation technology actually takes all of the different aspects to an entire workflow and brings that into a set of processes that a software robot can take care of. So for instance, if you have to go onto a website, grab some information, put in an Excel document, generate a report, and send it to a partner at your firm, you can actually use a robot to follow those exact tasks and send that information. But keep in mind, this is technology, and you always have to verify and check your information. So the big difference is these tech companies are less flexible as far as what you can do with it. And automation technology can bring in different system, different application, and get an entire process completed, and not just one task.
Yeah, the thing to keep in mind when you're looking at any product in technology is that no matter how shiny it is, it may or may not be the best investment for, a law firm or a company to make. And the types of automation technologies that we are working on do include those types of tools, but it's really wherever the pain point is, wherever an organization's team is spending the most time on manual tasks, that's where you can further automate with more technology. So our approach and what we look at is really need-based as opposed to product-based, although products can be part of making sure the need is met.
So specifically in the litigation space, what benefits could litigators enjoy if they effectively implement automation and advanced technology solutions?
Time. And time is a big thing I know for our litigators. I've been working with them for about 20 years. And time is important. Well, they'll have time to build their professional career, work on more strategic workflows, work on things that requires and uses their skill set.
So there's never enough time or money. I think we can all agree on that. So how do those limiting factors affect attorneys' adoption of new technology solutions?
Attorneys are very reactive. They're used to dealing with a problem when it arises. If the need is great enough, they'll go seek a technology solution. And usually to be great enough, the need has to be so great that they don't think they can possibly solve it in the context of their case without technology. But otherwise, even just learning how to use a new tool that's an investment too. That's time that you're spending learning how to deal with a tool you've never used before when you have an old, reliable way that will get you where you need to go. And without taking the time and risk to try something new in the middle of an urgent need is not the way to go. And that means that people really have to be proactive in how they come at this. They have to say, these are the general needs of my group and my team. These are needs that might come up in an urgent situation and prepare for those. But also, if you really want to start there, I think that most legal teams, if not all, have room to reduce their manual processes in some form. And so the time available to go deal with that and explore options is not something most people want to make room for, but I do think that it is essential to remaining competitive, especially as the tools that are available become more and more sophisticated and other groups are going to be using them.
So let's say we get over the hurdle of time to look into these products, consider the products, the tools, the resources. How would an attorney get started testing the efficacy and appropriateness of an automated tool? Do they hire consultants or work with vendors, or do they just purchase a product off the shelf and trust it?
Sometimes, yes to all. It depends. And I think that this really starts with what their needs are. I look at this as some groups, if this phrase resonates with you, then you have a need, and that is shoveling data by hand. If you are moving data from one place to another, or you're constantly digging through similar stores of data, looking for new things or things that you need, then you are shoveling data by hand, and you have perhaps a need that can be solved with automation. And looking for where your team or yourself, you're spending the most time on those types of tasks. That's what you go out and do. So once you've done that, then yes, you can go start looking at products. One of the worst ways to approach this in general is seeing a shiny object and deciding that it's really pretty, and now you want to go explore that because it may be a very good product, but it may not be the thing that is best for you to invest in at that moment. So start with evaluating where you're spending your time and have the most need for savings. And then I think from there, go find solutions. And then once you have one, if you're talking directly to a provider that has an off-the-shelf product that appears to meet your need, then ask them for something that legitimizes that their product works. If it is something that is a little bit opaque to you. So especially when using AI, you really do need white papers, research studies, whatever they can give to you. If you don't know how to interpret what they send to you, then you might need a consultant anyway. But I also think that you can dream up a solution, and that's where we do custom things. So we ask people, think what your pain points are, and then you tell us, and then we can see if we can design a solution. And so in that case, you are hiring a consultant to help you work on what your need is and what it will cost to solve the problem that you're talking about. And that might include one or several products, or there may not be products available. Wherever something's already built, that is usually a good option, but we want to make sure that it actually works.
When you say shoveling data, you're not limiting data to numbers, to Excels, right? Is that, you just mean information generally?
No, let's be more specific. Wilzette, do you want to talk about some of the examples of how automation can help we've saved some clients money, and we know how automation can solve pain points.
One example is we had a client that came to us, and they were monitoring over 800 regulatory proceedings on a website, the government website, that's definitely related to their cases. But what they were doing to access this data, attorneys were logging in every morning and looking for any changes or modifications that were made on these sites. And obviously, this was very expensive, time-consuming, and error-prone. They wanted our team to design a workflow or a procedure to make it easier and faster for them. So our development team used Robotic Process Automation, and we created robots that were able to go on these websites and scrape the relevant information. So we extract documents. We also extract metadata that was related to the document. So metadata is the user, the date, or any information about the document that they felt was important. Once we pulled the documents down, we were able to create a structural text where we can load it into a database system where they can log in and run their searches. So they didn't have to go in every single day and run these searches and look for any updates or changes. They were able to just go on this website to see what was changed and how the information was changed. This way, they were able to go back to their partner and give them a status on how the case was going, if something was new or if something changed. This particular workflow saved them a lot of time, a lot of headache, and definitely saved them a lot of money.
Tara talked a little bit about understanding the automated tools. Are there any other risks, pitfalls that people need to be aware of before they implement a solution or build a custom solution?
Yeah. So you need to make sure when you're looking at what it does that you understand the intended use. What is the use case? And that should be what you test. And be aware that people are enterprising and they want to do their jobs well, and they may find other use cases as time goes by, or not understand that they are confined to a particular use case and that they don't understand what flows through. And you really need a training process. You need an onboarding process to make sure that everyone's familiar with how to use the tool correctly, and what is an acceptable or proven use and what might be an off-label use of the tool. And if there are off-label uses that are cropping up, you really have to address those and see if they're addressing additional risks. So as an example, with the blow up of generative AI, we're seeing a lot of incorporation of RAG systems, or retrieval augmented generation. And the way that these tools work is you could submit a query, and before it writes a response to you, it's got to decide what it wants to rely on for its response. And it will go and find some source material to summarize to respond to you. So that's the retrieval part. And retrieval could be 5 files, it could be 20, it could be 1,000, but it really depends on what you're doing. And if you were under the impression that it was going to search a set that it isn't going to include, maybe that it's actually going to summarize everything, an entire corpus for you, but it's really only checking 20 documents, then you need to know that so you can plan a workflow where, okay, sometimes this is really useful, but we can't take it as it's really run across an entire set. We might want to check what it's actually pulled and what it's referring to and see if we think that's a good set for it to be relying on, or if something might be missing from that. So that's just one example where not understanding what the technology is doing under the hood in some fashion could cause you to misunderstand what it's intended to be used for and where the limitations might lie.
In Wilzette's example of how firms and lawyers have upped their game using these solutions, she described a public data source. But if you're building a tool or using a tool that's working with a private data set, proprietary data set, confidential data set, you're always going to have issues of data security and privacy considerations. Can you talk a little bit about those in the implementation of tools in a legal workflow?
Yeah, I mean, for the most part, the idea of sending private or confidential data to a cloud is not new, or should not be new, and is generally dealt with through contracts. I mean, I'm old enough to remember when people used to come check data centers, and there were armed guards you could go visit and say, "This is where your data lives," and you couldn't really check that's where the data was. So certain things you still have to take at face value, but today you can't really go do that. And in fact, there's some ways of setting things up where the data it goes places but never really exists except in an ephemeral way in certain servers, or it's serverless. I mean, there's so many ways of setting this up now. You kind of have to go on, is this a reputable vendor? What is known of their reputation? Have they had any incidents? What's been done about those incidents, if so? And your contractual provisions. Who's assuming the liability and what representations are being made? Does that give you enough information to tell your own clients you've taken the necessary steps? You can look for certifications like SOC certifications and try to get the paperwork in place to show that you've made reasonable decisions and who you rely on. You can't plan for everything and what's baked in. The complexities that have been added by generative AI, one thing that people have really focused on for this one is that it could be true for any AI system, but the generative AI in particular is aggressively using any queries as new input data. The prompts could become part of the model. And this has a lot of people scared. If you are in one of the current collaboration platforms that's popular, I promise someone else has access to your company's data at all times. They just generally are not going to actually go use it. And so one of the things you have to keep in mind is who has access to this data, even within the company that is receiving it. So do they have employees that are doing quality control? And they've taken steps to lock down who has access to things, and how much do you care? Like, how much risk is there in, an internal employee who has their own confidentiality requirements going and looking? And it really depends what you're dealing with. And so you have to take into consideration as an attorney, how sensitive is this data? You also have to keep in mind actual regulations. So the EU Data Privacy Act is always something that we are worried about, GDPR, because those are strict requirements. Confidentiality to our clients is a strict requirement. Privilege protection is a strict requirement. So you have to think about all those separately and think about what is reasonable to take on word of your provider versus maybe it's not acceptable. And if you're dealing with something really confidential, then you may have to go further steps than if you're dealing with something that is confidential in a client sense, but isn't something that runs a huge risk. For example, if you're dealing with government contracts or things of national security concern, there are other options offered by some of the AI providers that they'll even take off the table that they'll hold your data for a small amount of time where it might be reviewed if they think there's a violation of their policies. They won't even do that. So you pay more for that, and that's all part of the decision. But at a high level, it's not a good idea. It's never been a good idea to go put your client's confidential information into a Google search because you have no contract with Google in that sense if you put it into a Google sense and into a Google query. And so same thing with prompts, like do not put things that are confidential into a prompt in an unsecured kind of public version of an account. You have to go and pay. I don't think there's anywhere you could do it without paying. So you have to pay for a higher level of security.
So it sounds like there's a lot of potential value to these tools if you do the homework required to make sure that it's doing what you think it's doing, you understand what information it's capturing, how the data is being used, and appropriately utilizing the data on the tail end. And so in light of that, why are some lawyers making use of these types of tools while others have taken no action to implement them?
We have some lawyers that are excited about technology and they want to use it to increase their workload, work more efficiently, and see how these tools will make their work, day-to-day work easier. These are attorneys that are considered tech savvy. They love technology. They think it's a good opportunity. But there are other attorneys, on the other hand, that are a little bit afraid of technology. They have their processes that they've been using for years. It works. They have no issues with it. So they do not want to they don't want to learn something new. They don't want to have their process in a tool that they can't see the back end. They don't know what's going on. So they're really nervous about, should I even bring this tool in? There's also issues of cost and resources. Some small companies do not have enough money to invest on these tools. They're not sure how to bring them in, even if they are interested. There's no one in the department that would be able to analyze these tools, see what works best, and see what process they can actually implement these tools on. Even though that technology at the point right now, automation technology is not being utilized at the same pace, but eventually we're all going to move to an industry, legal industry, where technology is not an option anymore. It's actually, you have to start bringing these tools in so you can be competitive with these other law firms, with these legal departments and vendors, because they're using the tool. So you'll have to start thinking about, how can I start implementing at a small level some of these tools, so I can actually provide better client services based on the task that I select.
So the same process we went through when we were moving from book research to electronic research, where initially it's that black box factor, and you slowly move through that as an industry where, honestly, I think for some professionals, it's much less about eliminating the black box than recognizing that everyone's in the black box. I don't know that anyone can really tell you with confidence what's happening behind the scenes of their research vendor sites. I mean, I think we know in theory, but auditing that can be really difficult, but we've all just gotten comfortable with it. Is that a fair assessment?
Yeah, that is fair. And like Tara said, being able to speak to these providers and having them give you documentation that this is what's going on, and you have proof that you actually took that extra step.
Anything to add, Tara?
Over 10 years ago, when I would talk to attorneys about technology-assisted review and use of machine learning in document review, there was a lot of mistrust about this, and still is, because of the black box factor. And so what we would tell them is, look at the validation metrics. We just want to see if the process worked. And so you don't have to worry about the weights that happen inside the formulas that go into the model. You need to see that the model did its job correctly. And that's what we're going to focus on. It shows your process was reasonable. And to demonstrate this, I used to ask people, how many of you today would get onto a plane if there were no pilot? And nobody would raise their hand. And I would say, well, what if I told you that we're like 20 years in the future and it's just normal that you get on a plane and there's no pilot, like they're flown by robots and there's been no incidents and this is the most safe thing ever. How do you feel now? And they'd say, oh, that's okay. And I'd say, okay, because now you have evidence that this is okay. And I had to stop that way of talking to people because more and more hands would go up. People are totally fine flying on a plane. Now, I still want to know there's a human there to take over if the robot fails. But I think, now we have self-driving cars at a level that wasn't even, I think, on people's minds at that time. And it looks a little weird to us today to see if we were to see a car that doesn't have a driver, but we'll get used to that too. And so I think what you're saying, Sarah, is exactly right. Artificial intelligence has always referred to that thing that we expect humans to do and is now being done by an artificial intelligence, a machine. And so that's always going to keep moving, and getting comfortable with black boxes is sort of the way of the world.
So the early adopters right now are really taking the weight of the initial research, the initial testing, the creating that comfort in the industry, and then the rest of the industry will catch up.
I would say for artificial intelligence, that's right, especially given that there's regulations and risk frameworks and a lot of attention and more technical compliance you'll have to worry about with uses of artificial intelligence. But as Wilzette explained, automation and robotic process automation are much, much broader. And this is where we can look for things that just seem like low-level tasks that people are doing over and over again at their computers and may be able to be automated.
Well, it's exciting times for firms and attorneys who want to lead the industry and adopt these early so that they can get that extra edge. It's really great to know that there are organizations like Redgrave Data consultancies to help them get comfortable with it and understand what's happening and how their data is being used so they can do this effectively and really reap the benefits. I want to thank you both again for your time and congratulate you on your forthcoming book, Legal Operations in the Age of AI and Data, which again is available for pre-order from Globe Law and Business.
Thank you, Sarah. It was great to get to talk to you today.
And a thanks to Tom Hagee for letting me hijack this podcast to explore these issues.
That concludes this episode of the Emerging Litigation Podcast, a co-production of HB Litigation, Critical Legal Content, VLEX Fastcase, and our friends at Lost G Media. I'm Tom Hagee, your host, which would explain why I'm talking. Please feel free to reach out to me if you have ideas for a future episode, and don't hesitate to share this with clients, colleagues, friends, animals you may have left at home, teenagers you've irresponsibly left unsupervised, and certain classifications of fruits and vegetables. And if you feel so moved, please give us a rating. Those always help. Thank you for listening.